We got a text question here. Christy, why don't you read that out for us?
Yes. The texter says, my husband of 30 years died in December 2020, just this past December. First of all, our deepest sympathies to you. We're very, very sorry. The question is there a time limit on starting a probate on his estate?
So the answer is no. You can do that probate estate next week, next month, next year, 5 years from now. But let me qualify that a little bit. If your husband died owning not the home, let's say that he's got a vacant lot somewhere in his name only. That lot is locked up. You will not be able to sell it or refinance it or do anything with it until the probate is done. Okay, so if your husband died with an asset in his own name, just understand that's going to be locked up and it's not going anywhere until the probate's done. Time is not going to change that fact that probate is needed. Number two, occasionally, Chris, I get a phone call that goes like this. Tom, my dad has passed away. He named my sister as the executor. He died a year ago. She's not doing anything. Okay? Why should I be waiting around for my sister to do a probate? This is her job. She was named the executor. Well, what I tell that caller is, yeah, she was nominated to be the executor, but any interested party can go start that probate process. So if the sister's throwing up her hands and say, I don't care, I'll wait. There's no hurry for me, There's dad died with money in the bank. I'm well off. I don't need it. I'll just wait, take my time, do it when I want to. Well, maybe the other siblings don't feel that way, sister. And so with that said, that even though she's nominated to be the executor and take care of the estate, if she's not doing that, then any of the other beneficiaries can start that probate process.
I think that's important for people to know that because, Tom, you're right, that is a common question. That there's one sibling that's in charge, but they have not done anything for whatever the reasons, but any interested party can start that process. In this situation, of course, it's very likely that the widow here, that they owned everything jointly. And so it's possible that there would not have to be a probate.
That's what we tell people. Most married couples own everything jointly. That means when one of them passes away, the survivor automatically owns it all. No headaches, no hassles, no probate.
Exactly. So
she says probate for husband's estate. Typically that's not required unless he happened to die with an asset in his name only, like a bank account or a piece of property.
Exactly, where he forgot to name his wife as the beneficiary. And once in a while that does happen, and certainly we do probates for that reason, but for the most part, married couples, that will not happen. When one passes, typically the surviving spouse will not have to do a probate.